Good morning. Thank you for joining us for today's webinar hosted by Zuber, Lawler and Proclinical, titled How to Protect Your Medical Device IP. We're really pleased to be joined today by Matt Young, who's the Vice President of Global Operations at Glaukos. Our panelists also include Mark Bloomberg of Counsel at Zuber, Lawler, and of course, last but not least, Eric Silverman, the Director and Assistant Chief IP Counsel at 3M. And my name's Claire Perry. I'm a Senior Partner at Proclinical. I'd like to go through and give you the bios on each of our panelists. I'm going to start with Matt. Matt has over 20 years experience in the medtech and pharma industry. He's a highly accomplished senior operating executive, skilled in supply chain functions and with a command of executing product launches, including strategic planning, R&D, process improvement, Lean Six Sigma, DFM, manufacturing automation design and quality. Matt has seen success in leading global cross-functional teams, improving processes, expanding capacity, and optimizing organizational efficiencies. His sweet spot is mid to late stage scale up to commercialization. Matt is currently the Vice President of Global Operations for Glaukos Corporation, where he works collaboratively with executive management and the board in leading the company through a transformation from a device-centric to an innovative world-class pharmaceutical business. We also have Eric Silverman. Eric is a Director and Assistant Chief IP Counsel at 3M, where he supports the healthcare business group. Eric was previously an associate in the Washington, D.C. office of Cooley LLC, where his practice was focused on pharmaceuticals and medical devices, and a primary examiner in the United States Patent and Trademark Office. He holds a BS in chemistry from Carnegie Mellon University and a PhD in chemistry from the University of Florida, and a JD from the George Washington University Law School. Last but not least, Mark Bloomberg. Mark is a patent attorney and litigator. He holds 2 engineering degrees from MIT and graduated cum laude from Harvard Law School. Between his time at MIT and earning honors at Harvard Law School, Mark worked literally as a rocket scientist. His capacity to quickly absorb varied scientific subject matter is extreme. Okay, thank you and welcome, everyone. And then I should introduce myself. So I'm Claire Perry. I'm a Senior Partner at Proclinical Exec Search. I did a pre-med at University of Tech, Sydney. And then I have 8 years in search. I've completed over 200 searches in major US cities, as well in Paris, Milan, Dubai, Barcelona, and Rome. And Proclinical is an exec search firm that focuses specifically in the health tech, med tech, and pharma space. Okay, so we're going to dive right in. We have some questions for our panelists. So we'll start off with the first one here. When should a patent be filed? Mark, do you want to take this one?
Yeah, sure. Thanks, Claire. The basic answer is it should be one of the first things that you do, and you should do it as soon as possible. And that means, in particular, you want to do it before you disclose your invention to anybody. You want to do it before you offer it to sell for anybody. You probably also want to do it before you start dealing with any partners. And by that, I mean, maybe you have somebody to help you with manufacturing. And before you disclose to them, you want to be filed. Oftentimes, when you're dealing with another company or another person, you have an NDA in place. They do not always work. So one should prudently assume that they will not work. I think Eric's going to talk about that a little bit later, but there are problems with that. And certainly, you want to file before filing anything with the FDA. The reason for it is that if you don't do that, you may use your patent rights. And in particular, most countries outside of the United States have this idea, which they call absolute novelty. And that means that if the invention has been disclosed by anyone, including you, prior to the filing of the invention, you lose your patent rights. And in this day and age, people are surely going to have good devices sold throughout the world and are going to have patents in appropriate places, and you don't want to lose your foreign rights. So that's the reason that you wanted that outside the United States. The United States is a slightly different rule. What there is there's like a 1-year grace period to file the invention after disclosing it. It comes out of the 1880s, and the notion was that if you had some invention for a horse buggy or something like that, you could try it to see whether or not it would work in the market and then file a patent later rather than going through the time and expense. That really doesn't make any sense now because that's not what's going to be happening with a medical device. But more importantly, there have been a couple changes in the law that are reasons why you don't want to do that. One is separate apart from the foreign patents. One is that in the United States, the first to file is now the person who would get the patent, not the first to invent. So if you invent something and then you try it and then you file your patent a year later, but in the meantime, someone else has independently come up with your invention and filed it, you lose, even though you were the first inventor, and you don't want that to happen. The second thing is it takes a while to get a patent. And so you want to get that process started as soon as possible so you have the patent as soon as possible. Particularly since when you're talking about medical devices, it's an evolving field. The products have relatively short lifetimes, and so you want to have as much patent protection as possible. As an aside, if you're just dealing with a pharmaceutical product, you may do things differently because a real landmark kind of drug will last a long, long time. And so it's good possibly to push out your coverage a little bit further. And you don't need it right away because you have to kind of get to the FDA first before you can start selling your drug. One thing that you can do, because sometimes you're not ready to file as soon as you need to, is there's an idea you could file a provisional application. And what that means is it's sort of it's a patent application. It's not a real patent application. You disclose what you disclose in it. It's simple, and you'd have to file a real patent application after that. There are pluses and minuses to doing that, but if you're about to disclose something and you don't have time to do a full application, it's an emergency solution to your problem. And so the bottom line to all this is when to file as soon as you possibly can.
Wonderful. Thank you, Mark. On which subjects should you file patent protection versus which should be kept a secret? Eric, do you want to take this?
Great, thanks. And so this is one of those questions that can be very case specific to your particular device. And so what I think I'll answer the question by kind of walking you through some of the considerations and the things that you'll want to keep in mind when you're making this decision as to whether to patent something or whether to attempt to maintain it as a trade secret. And so the first thing that you will want to think about are what are the mandatory or in some cases expected, if not strictly mandatory, public disclosures surrounding your device that you're going to need to make either for regulatory purposes or for acceptance in the market, right? If you need to publish scientific papers, for example, because your device is something where users will want to see that before they'll accept and adopt the device. And if you are going to need to publish those, clearly you're not going to have the option to maintain a trade secret on something that you're going to have to publicly disclose. So that's one thing that you'll want to think very carefully about before choosing to attempt to maintain a trade secret, because you may not be able to do that. The next issue that I'll mention is the issue of policeability. And what I mean by that is, assume that you file a patent application and that you get the patent of your dreams that covers everything that you wanted to cover. Would you actually know if someone was infringing that patent? Is the patent that you're going to seek, is it going to be something where you can look at the claims and you can buy or obtain a competing device and just simply compare it? Or is it a patent that's more directed to sort of a process, or does it have manufacturing components that are limiting the patent, where you may not have any reasonable way to determine whether an infringing product is going to actually, or competing product, I should say, is going to actually infringe the patent and actually practice those steps or have those features in them. And so you'll want to think very hard about what you think you're likely to actually obtain vis-a-vis patent protection, and what your final claims you think are going to look like before you make that decision. Because if your patent is not going to end up being, it's just going to end up being difficult to police, then you may think that, well, let's try to keep things a trade secret if we can. Another consideration that is very important is, what is the risk of independent development? So if I were to preliminarily think, well, I have this item, I think we'd like to keep it as a trade secret. What's the risk that somebody else is just going to develop it without ever looking at what you're doing and your secret? And because unlike in patent world, it doesn't really matter whether someone is aware, well, it doesn't really matter, right, how someone obtains the patented device. The patented material will infringe, right? If it infringes, there's an infringement analysis, and you do that. But for trade secret, trade secrets only apply to things that are difficult to ascertain by reasonable, by proper means. And if your innovation is not, because it's a great way to manufacture your device, you know, maybe that's a good idea for a trade secret, or maybe it's not, because it would be easy to ascertain it by just buying and examining the device itself. The last one, which is sort of the last of my technical items, and then I have one that's sort of non-technical that I'll take on, which is life cycle. How long is the innovation going to be good for? So Mark was talking a moment ago that the medical device industry is often changing very quickly. Products may have short life cycles, or they may not. And so to the extent that the commercial life of your product is going to exceed a patent term, you may consider seeing what you can retain as a trade secret to keep it out of the world of public knowledge for as long as possible. And then the last item that is always important to think about, because it's top of mind for certain types of companies in making these decisions, is investor expectations. If you're a small investor-backed medical device company, there may just be an expectation from your investors that they're going to want to see these patent applications filed. And if that's something that's really important to you, then you may just need to do that. If that's what's important, and if that's less important for one reason or another, then you may not have to consider it. But if you're watching this and you're a patent attorney, it's always something to keep in mind when you're talking with your clients.
Okay, thanks so much, Eric. What are the risks versus the rewards of manufacturing in a low-cost region or low-cost regions? Matt, do you want to take this one?
Sure, thanks, Claire. So when you think about your patent estate and the knowledge that you got, certainly piracy, outright piracy is one thing to be worried about. Kind of in the middle ground, there's the leak of knowledge, whether that be product or process or both or somewhere in between. I think there's also risks with respect to, when you call it here in the domestically, when you think about developing a product, you're doing so to a particular set of standards and guidelines. For example, our domestic levels of quality or standards may be a little bit different somewhere. So you got to think about organizationally how you transfer your full set of expectations to what the product looks like to where you're going to outsource. And there may be the difference between those two, and how do you bridge that? And then I think lastly, the other thing to kind of think about is from a development perspective, potentially are there ways to develop products that may have specific features to specific regions where you may not, you may have lower levels of technology or knowledge that get transferred to lower cost regions where you may be able to protect better the product that you've designed in a key domestic market, let's say.
Wonderful, thank you. Thanks, Matt. That's really helpful. What types of claims should be pursued for a patent to achieve effective enforcement? For example, should apparatus or systems or methods be claimed? Mark, do you want to take this one?
Sure. This is a very important and often overlooked question, which by the time you get the patent down the road, everybody feels sorry that they didn't think about this as much as they should have up front. And the first question one needs to ask is not a technical question at all, but it's a question of what is our business and what do we want to protect and where do we want to go with this thing? What is the point of it? There are many kinds of patents you can get. You can get a patent on a device, on a system, on a part of a device, on the material in the device, or in the way of using the device. And so the question is what do we want to do and why? Now, the first problem you end up with is there's a disconnect between two groups of people who have different perspectives and skill sets. There are the people who obtain patents from the patent office, and there are the people who actually do something with them, be they license them, be they force them to sue somebody. And they're two different people, and they look at these things in different ways. The people who are in the patent office, work with the patent office, view the patents in terms of what is wonderful about them technologically, what is really new about them technologically, and they're very excited about that. And then they deal with the patent office and try to get claims to really cover what is innovative. The problem is the other people, what they're looking at is they're looking at what is important commercially. What do we really care about? How do we fit in with everybody else? That is the more important position, but it comes after. Or it could come after, and it never should. What's really critical in deciding claims is you need to have some business-oriented person who understands the business, speaking to the prosecuting people trying to obtain the patent up front, so you get the right kind of claims of what you want. Also, there's some issues that beyond that you have to really work out with it. But when you're trying to get a patent, you think it's wonderful to get a patent, although you might get a patent on a claim that's not really useful or commercially. The other thing you have to be careful about is you can get a very, very broad claim, which is wonderful because you convince the patent office to get you this great claim. Problem there is if it's too broad, it's not valid. And so it's wonderful in the patent office, but when you try to use it commercially, you've got problems. So a lot of communication needs to take place so that the people getting the patent get you what you really want and you really need. Now, there are a number of purposes for a patent, and Matt touched base on them. And so you have to ask yourself, well, what do we want this for? You could want it just to cover your exact device to make sure that nobody copies you or knocks you off. You could use it because you have in mind wanting to protect, enforce it, bring litigation if necessary. It's going to be a very important, profitable device, and nobody else should have that device in your market. You could decide that what you'd like to do is you'd like to license it to others, so you let them do all the work, and then you'll just get a royalty for it. And there may be things that they can do, or other businesses, or they have abilities that you don't have. That would be helpful. And the other thing that I think Eric touched upon is you may be looking for financing. You may be looking to want to sell your company altogether. And in both instances, that drives what kind of a patent you might be looking for. And so it's key that you need to understand the business and how it all fits in. Now, that being said, what claims do you want, who do you want to cover? And the answer generally is going to be other suppliers of products. You want your competitor or someone else is going to make a medical device to be the person who infringes. That drives you away from the method, because if it's a method, the person who is selling the product is not going to be infringing. The person who would be infringing would be presumably some doctor who's using the device. And that means you have to go through more hoops, because you have to sort of say, well, the company was not an infringer, it induced infringement. That's harder to prove. You don't want to be there. So you want to set up your claims so that they are the infringer. The other problem with doctors is not that you'd want to go and sue thousands of doctors, but you can't, because there's a provision in the patent law that says that you can't get damages from individual doctors. And so you wouldn't want to do that anyway. And another person who you could, or group of people that you might want to sue, is maybe hospitals. Again, they could be in a circumstance that's what you want to do, but unlikely, because rather than suing the one manufacturer of the device, you have all the hospitals that do it. And beyond that, you have problems suing hospitals because, for example, if you want to go after the VA, that is the federal government, you can't sue them for patent infringement in a district court. You have to sue them in a different place and a different claim. If it is a state-owned hospital, you can't sue states for patent infringement. And so that becomes a problem. And so you're left with not being able to sue all the hospitals, having many, many lawsuits. Who wants that? Who needs that? You can't sue the doctor. So get your claims to cover another medical device manufacturer or supplier. And that is really going to be the way to go. So when you have all that in mind, understand your business, talk to your patent prosecution people, and make sure they get you the claims you want and you need. Thanks.
I'll make one comment that I think is one of the, Mark did a really good job of covering all that. And there's one other thing that I'll mention that I think is occasionally, when applicable, it can really be an underutilized, I'll say weapon in the patent arsenal, and that is design patents and design registrations. Depending on the nature of your medical device, the design of the material, the device itself, can be very important to the device's ultimate use, or even if not use, just market acceptance. It doesn't have to be the technical use of the item. It may just be the market acceptance requires it to have certain design characteristics. And so thinking about whether design patents might be applicable and how to fit them into your overall strategy. I will say that at least in the US, there have been a few decisions over the last year or two, Surgisil and a few others that make it somewhat easier to obtain design patents. And for the maybe I won't say that they make them much harder to enforce, because if you're looking to enforce a design patent on a medical device against other medical devices, doesn't really create much of a burden. So just another tool in your toolbox that you should really consider using and discuss with your patent strategy team.
Thanks, Eric. Okay. What is the coordination between IP and regulatory? Eric, do you want to take this one?
Yeah, thank you. So this is one of the, I'll say, occasionally overlooked aspects of developing a patent strategy, and really to the detriment of the innovators when you don't listen to that, when you don't think about this. And so the first part, right, which is probably the most clear and obvious part of this is avoiding contradictory statements and representations to different government agencies, right? There's one government agency and one set of people who are talking to the patent office. There's a different set of people talking to the regulatory authority, whatever that may be, the FDA usually in the US, or if you're outside of the US, your equivalent authority. And contradicting yourself and saying two different things to two different parts of the government can create various problems. But there's more to it than that. Because having a good understanding of the regulatory pathway can really help bolster the effectiveness of your intellectual property in doing what you ultimately want it to do, which is either create licensing revenue or keep competitors off of the market. So the way that I like to think about it is, intellectual property and regulatory are both hurdles in the path of a potential competitor. And so, but if you can, they may both be very low hurdles, but if you put one hurdle on top of another, all of a sudden it's double the height, right? So it's much harder to jump over one high hurdle than it is to jump over two really low hurdles, right? So So to think about this as far as medical devices, right? Understanding what is the likely regulatory pathway for your medical device when you're first developing your patent strategy. And so, is your device going to be regulated as a device, as a drug, as a biologic? And that's something that's always changing. In fact, the FDA in the US has only very recently issued some new guidelines about how things are regulated and how combination products are regulated under which category. And the regulatory pathway is going to determine what a follow-on competitor would need to reference and need to do to overcome the regulatory hurdle by saying, well, I've got this new device and it's just like theirs, so FDA, let me come market it. And so once you understand that, then you can think about having your IP strategy track your regulatory strategy, so that it would be, and you can make it difficult, if not impossible, for someone to say, have a 510K that references your device without also infringing your patents. Because if those two don't track together, then it becomes easier to design around your patents. And it's something that you need to think about it, not just when you're setting your strategy, but also when in the interactions and the give and take with the patent office, where you say, well, I'd like a patent that's this broad, and the patent office says, well, no, how about that? And you go back and forth. Because if things change quickly on both ends, and if they start to get off kilter and they don't line up, then all of a sudden you've created large holes in what maybe could have been a pretty solid patent fence around your product.
Thanks, Eric. How do you protect your IP when you're thinking about outsourcing? Matt, do you want to take this one?
Sure, thank you. So this kind of ties into something that Eric talked about a little bit ago, and what it is you patent, and what's the risk that someone's going to arrive at the same place that you did with a product or a manufacturing process. And so some of the things that come into thinking for outsourcing are, I think I tend to start internally and ask the question, what is it that you want to have as a core competency for your company? And when you're thinking about a new product, if this new novel product also has a new novel manufacturing process, those may be things that you don't want to outsource, and keep that as part of the IP strategy and or trade secret. If you do decide to outsource, on one end extreme, right, you might outsource everything, in which case you have to think about how do you control your outsourcer. And there's certain agreements and things beyond NDA which you may be able to implement and enforce, but that leads to other questions. If the outsourcer is also manufacturing for other companies, you can control your outsourcer, but if there's other people that will be on that manufacturing floor, you may not be able to control them or what they see. So those are things to be concerned about. Another opportunity. So the full outsource was one extreme. A second extreme on the other end of the spectrum could be you might make decisions about how you manufacture and perhaps split pieces of your manufacturing to multiple outsourcers, so that you're not sending all of your technical information, knowledge, manufacturing know-how to a single source. And as you dilute that, right, and you bring those pieces together through another assembly process, let's say, it's watered down, so you reduce the risk of what it is you're leaking out. Those are some of the kind of the key things that I would focus on. And I think, again, it kind of comes back to what do you, as in your business, what do you want to be have as a core center of excellence in terms of what you want to do? Because if it's truly novel and from a manufacturing process perspective, that may in and of itself spawn additional products that you could also have further IP on in the future, and keep that to yourself.
Yeah. Another thing to think about for outsourcing is you may find the most reliable and trustworthy company to be outsourcing your manufacturing, unfortunately, that company goes bankrupt. And if that happens, you want to make sure that any licenses that you have to them don't carry on to anybody else, that any trade secret that might be in their possession, it's clear it's yours and it comes back to you. And any know-how or any tooling that they might have comes back to you, because you don't want to be in a situation where they're bankrupt and all of a sudden your IP ends up in the hands of a creditor or someone who decides, gee, how about I buy out that bankrupt company, and that way I'll get the crown jewels from my competitor, particularly if you're talking about trade secrets or something like that. So it's something really to protect against, which is an unhappy thing to think about, but it's something to think about.
Yep, it is. And you know, another thing, you know, and Mark explained pretty well earlier why product patents tend to be favored for enforcement and for looking at, you know, who is it that you actually would want to enforce a patent against. But this is one of the cases where, you know, patents regarding manufacturing processes can actually have some value in protecting you, because they can add another layer of protection, because, you know, it's often difficult to know, right, whether your patented manufacturing method is being carried out by, you know, some third party. However, if it's your own supplier and you've taught them how to do it, and now, you know, the relationship perhaps breaks down or things are going on that you may not like them to do, it's a lot easier to be able to, you know, kind of come back and, you know, and potentially enforce or hold this patent over their head and say, wait a minute, you know, in case you were thinking about, you know, whatever it is that we don't really want you to think about, we do have this patent portfolio covering all of the things that we're teaching you how to do. And, you know, so don't.
Yeah, and I do think in many cases, you know, when you're going to a third party, they're going to have some expertise, you're going to have some expertise, and you're both bringing something to the table. And that relationship management is really important in terms of helping them keep your things secret.
Because if their commercial expectations are being met by the relationship, that then they are, you know, then you're in the same boat, and they have just as much incentive as you have to maintain the secrecy of your processes, because they're, you know, presumably you're making money, they're making money, everybody's happy with how much money they're making, right? That's, you know, when that's not happening, then that's when you can potentially see things break down.
Okay, well, while we're on that topic, how do you choose a trusted partner manufacturing new and novel devices? Like, how do you know who to trust? Matt, do you want to talk to this?
Yeah, sure. It's that's a tough, you know, question. It's almost like you know, there's some analogies to courting and dating, so to speak, right? You know, kind of two people come together and you kind of, you know, get to know each other and understand where you're coming from, and really understanding what their strengths are from a supplier perspective. And again, if you're coming to the table with something that's new and novel, right, there's an aspect of teaching them certain things, but you know, still holding back some of the cards. And I tend, when I think about outsourcing, I tend not to think about, you know, a lot of people think about suppliers, and it's really more about the relationship and partnerships. And you know, as Eric described a moment ago, you know, if you're both in it together and have very well aligned goals and objectives, it's much easier to do. And I think that's you know, it's hard to know from the outside. Everyone's got a pretty website. Everyone's got, you know, hey, we can do this for you, we can do that for you, and it's really, you know, kind of an on the ground relationship that you have to build, and to make it become a partnership. And there's some give and take on both sides, and as you do that, you build trust. And you know, as that product becomes successful, then there's trust to give the second product or the next iteration. So there's a lot of just relationship management, I think, that's you know, beyond the dotted I's and crossed T's of, you know, the patents, IP themselves.
Thanks, Matt. So be likable, probably. And then how should disclosure to third parties be restricted before filing a patent application? Eric, do you want to talk to this?
Yeah, sure. So, so this kind of, loops back to some of the comments that Mark made a little earlier, which is, file before you disclose. And that is, typically that will be the ideal situation. It is not always feasible to do that for a variety of reasons. You may need to, disclose to partners for joint development purposes. You may need to disclose to partners for testing purposes to understand what it is that you have and what it is that you actually want to file on. Or it may just be, there are many reasons. So the most typical way to do this, if you need to make a pre-filing disclosure, is you'll use a non-disclosure or confidential disclosure agreement, and you'll hear them by many names, CDA, NDA, but they all essentially serve the same purpose, which is to make an agreement. I will tell you something, perhaps you will tell me something, and we will not share it beyond us. Therefore, it will not be a public disclosure that could defeat patentability down the line. Now, not every NDA is ironclad or perfect, and not every agreement is equal. And so what does that mean? Well, non-disclosure agreements tend not to extend forever. Sometimes they do, but in many cases they don't. They're good for a year, 2 years. After that time period is up, that's it. Your material is no longer confidential, right? And your disclosures can be told to the public. The next thing that's very important is to understand whether your agreement is going to be respected, not just in the country in which you make it, but in any other relevant country where you may want to be filing for patent protection, because it's possible that, in certain absolute novelty countries, if your NDA does not meet that country's requirements, it will not be considered a confidential disclosure, and it will be a potentially patent defeating disclosure. So having the proper legal vetting is important, and then following up with a patent application at the right time is very important. And the last thing that can be important to consider is whether there's any money or anything else, what's changing hands in addition to the information. Are there prototypes changing hands? Are there items? Is there a development relationship, or whether it's formal or informal? Because at least in the United States, there's an on sale bar, which is separate from the public disclosure bar, and the courts in the US have recently clarified that even a sale that is not known to the public, and where the sale itself is kept confidential, is still a sale for purposes of being, prejudicing a future patent application and being patent preventing. And so that's a situation, once again, where you need to be very careful about the way that you structure the interaction and about the agreements that you put into place if you do need to go down that route.
Okay, thanks, Eric. We have a question. Can you also comment, I think this maybe was for Mark, can you also comment on the timing of FTO search and patentability assessment relative to provisional filing?
Well, you would probably want to do it beforehand. I mean, because what we're talking about here is we're talking about things that are going to probably be pretty profitable devices. And you don't want to go down that road and end up in litigation. So before you go too far, the sooner you know where you can operate and what you have, the better off you are, because maybe you need to get a license, maybe you redesign the product. But sooner rather than later, because otherwise what you do is you spend a whole bunch of time and a whole bunch of effort, and then you're stuck. And then if you're not stuck, then you decide to infringe anyway, and that's even worse. particularly if you're a willful infringer. So yeah, earlier is better from that. As soon as you have a sense, in fact, you could even do it before you design the product. If you were interested in a kind of product, it might not be unreasonable to make the investment before you even really begin to sort of say, okay, is this a field we can get into? And what's there, what's missing, what problems do we have, what holes can we fit in? Because it's not in anybody's interest to sell an infringing product. It's a total waste of time, and not there are other good products you can do instead.
Yeah. And maybe I'll add to something that I see quite often is the two types of searches and the two types of analysis, for one for freedom to operate or FTO, and on the other hand for patentability. They're not the same analysis, even though if you're not a patent specialist, you'll hear a lot of the same language. You'll hear search, you'll hear prior art, you'll hear validity, you'll hear claims, but they are actually quite different analyses, right? A freedom to operate analysis is and search is, what patents do other people have or other parties have that might prevent me from doing what I want to do, from taking a particular course of action, from launching a certain particular kind of product. The patentability search is, what kind of patent might I be able to obtain to prevent a third party from launching their product, from taking their course of action. And so they're related, but they're not exactly the same. And it's important to understand what you're looking at. And if it's not clear to you, have your patent counsel, spell it out to you for you, because you can proceed without a patent. That's a competitive business decision. That there are billions of products that are sold, and I'm sure that they're not all patented, right? And not all medical devices are patented. And you can proceed under that business model. You just may need to have your eyes open and be aware of it. On the other hand, you expose yourself to potentially, all kinds of liability if you don't have a freedom to operate. If you have a freedom to operate problem, that's a very different situation where you'll have to make some very careful decisions about how you want to proceed if you think that might be an issue.
Yeah, I mean, one way to look at that is if you had somebody talk to patent, they talked about vehicles, and then they claimed a motorcycle, you would not be free to sell motorcycles. That's the freedom to operate issue, because that's claimed. However, if you decided to make a car, that's great. You could do that, but you can't patent it because it's disclosed. So that's the difference between the two.
Thanks for that analogy, Mark, and thanks, Eric, for jumping in on that one as well. Which I know that I think it was Eric, you mentioned some patents are more difficult to police. Can you give us some examples?
Well, so there's a few different types. The first thing that comes to mind, and it's sort of I'll say it's the most common example, right? So this is maybe the one that's worth exploring, is patents that are either drawn to manufacturing processes, or that are what are sometimes called product by process patents, which in the US it describes a product, and it claims a product, but it describes it by the steps that are used to make the product. And so when the infringing act is a method, and it's going to happen, and the method is going to happen behind closed doors at someone's manufacturing facility, they're not giving you the keys to come into their facility because you have some suspicion without necessarily an evidentiary basis to believe that they might be infringing your patent. In the United States, you have certain bars that you have to meet in order to file a lawsuit, and after that you may be able to get discovery to find out where you actually might compel the other side to turn over information so that you could continue to build your case for infringement. In many other parts of the world, however, that's not necessarily possible. And discovery can be much more limited in other parts in other jurisdictions. And so that's really, it's an important consideration, right? When you're deciding whether to patent a particular innovation and what kind of claims you want, and what you want that patent to look like when it's wrapped up and granted.
Okay. Thanks, Eric. And then I know we also touched on, making the decision of what types of products to patent versus what to keep close. Do any of you have some examples of what you've seen, sort of the types of products that people aren't patenting? Yeah, can you give me an example of like, I mean, I don't know if you can, or like maybe in the reverse,
Yeah, well, one example is imagine you had some machine and it was driven by software. Maybe it's an MRI machine or something like that. It's going to be quickly evolving. And the other thing about it is the way the patent law has changed. If it's a software related patent, it's going to be very difficult to get a patent. And also, it's going to probably take you at least 2, probably maybe 4 years to get a patent. And so you might sort of say, you know what, rather than patenting that, I probably won't be able to get a patent. It'll be yesterday's software by the time I do get a patent. Let's keep that one as a trade secret. That's an example.
Oh, understood. Okay. And then, so I think the takeaways for me, this was amazing, and thank you all so much for sharing your advice on all of these topics. But really, the things that stood out to me, and there was a lot here, that stay on top of NDA expiration dates. Make sure someone's monitoring that. File as soon as possible. And then spread out manufacturing across a number of suppliers if you decide to outsource, so you're protected there, and then have someone assemble, somebody else assemble the product. I know we're a little bit ahead of time, but if there's no more questions, did any of you have anything else that you wanted to add, or any last comments before we wrap up?
Looks like there's another question that I'm seeing. That says, do you see this one, Claire? Any advice on getting a realistic assessment of the commercial value and protectability of a patent before investing a lot of money in filing? Countries converting to a PCT. This is all practical, sort of technical stuff about the processes of obtaining a patent. Patent attorneys believe in or tell you it's worthwhile, but it's difficult to assess, particularly with non-gizmo, so primary method or basic system claims. Do one of you want to take a go at that, or would you like me to? Or, I mean, my initial thought is that, if you're skeptical, right, you can have a patentability, you can commission a patentability search. There are many search firms out there. You don't necessarily even have to have an attorney to do the initial search, although I kind of recommend it because there are privilege issues, which is, can somebody be compelled to, can you be compelled to turn over the results of your search if there's ever a litigation? But you can commission a patentability search, and you can have that, you can have that analyzed before you start going down the road of drafting and filing an application. And you can use the results of that search to get a realistic assessment on the first hand of what kind of patent claims you might eventually get allowed. Once you've gotten to the point, right, and I think it's more important, I think, to determine what kind of claims, what are my claims going to look like, than just the question, can I get a patent on this? Because as Mark, went through in a lot of detail, right, getting a patent on this, what does that really even mean, right? I mean, it doesn't mean anything if you can't enforce it in the way that you would like to enforce it, if it doesn't meet your business needs. So once you've kind of made that determination of, okay, this is what I think a patent that I might get issued, or that I'm likely to get issued, would look like, then go ahead and you can take that, and now imagine you are, 3 years in the future, 5 years in the future, you have your patent, you have your devices is hopefully launching, right? And now you need to use the patent as a business tool. Can you do that in a way that would make sense for you? So it's really a lot about, doing the preparation work up front, and being willing to invest in doing that work up front, and thinking about that long game, and what things might look like in the future. And so it's a mixed question. There's legal advice that you're probably going to need to do that assessment, but you're also going to have a hard look at your business plans and at what else is out there and what other competing entities, competing companies are likely to do, both before you launch and then after you launch. What are the other players going to do in response to your launch? And those are hard questions, and they're not legal questions.
That's right. You really need two people to answer your question, because you have two questions. One is, what can I get a patent on? That's question number one. And two, is it worth anything? And a patent guy can answer the first question, but a business guy has to answer the second question. And you need to get the two of them together and to think the whole thing through to see if this makes sense or not. And then, of course, the business guy has to sort of say, okay, given the likelihood, does it make sense for me to make the investment in that? So, both in the patent and both in trying to build that business. So it really, and the danger that always happens is that each person thinks the other person has answered their question, and they don't answer the question, so the question never gets answered. That happens all the time. And Eric's shaking his head. And
it definitely does.
And it's a huge problem. It really is, because everybody sort of looks at it. What happened here?
Thank you guys, and thanks for finding that question, Eric, because I missed it.
My pleasure.
I'd like to invite all of our guests to connect with our panelists on LinkedIn. They welcome your request to connect there. And I'd like to take this moment to thank Mark Bloomberg from Zuber Lawler, Eric Silverman from 3M, and Matthew Young from Glaukos. So thank you all so much for your time today.
Well, thank you.
Thank you.